All right.
Hi, everybody. Thanks for joining us today for our discussion on information security and incident response. My name is David Butler,
And
and I'm
I'm
here
Brian
with
Ellis.
my colleague, Brian Ellis. We're lawyers at Bressler, Amory and Ross, and we work in the cybersecurity and privacy practice at the firm. We put together this seminar just to kind of do a high-level discussion of the issues involving information security and incident response, primarily directed at lawyers. But the concepts and issues we're going to talk about today are universally addressed to any small business or business. So bear in mind while we're going to talk about the different ethics obligations particular to lawyers when it comes to data security and incident response. These concepts of just what your obligations to your customers or clients for business owners apply equally across the board. Now we're going to be, if there's time at the end, we're going to be if there are any questions that come up, or if there's time at the end, we'll try to address some of the questions that we get in the feed at the end. But we'll get through the presentation first, and if we do have time, we'll reach out and discuss some of the questions that come in.
And just let me mention quickly, about a half hour or so in, I'll give the first CLE code, and then I'll type it into the chat. And then at the end of the presentation, I'll give the second code, do the same thing.
So this first slide here is a quote from, I think everybody recognizes the name, that's why we use it. Back in 2012, Robert Mueller made this statement. It's a well-recognized cybersecurity quote where he sees two types of companies, and ones that have been hacked and those that will be hacked. This is 8 years ago now, and I would say that his statement needs to be updated because now there are only two types of companies: companies that have been hacked and are going to be hacked again, because we want to make clear to everybody that there's an air of inevitability when it comes to security risks and the possibility that you're going to have a security, definitely an event, but definitely possibly a breach in your business, at your practice at some point in the future. The reason for that is and if some lawyers that have been practicing for a long time may remember that this wasn't even a thought really a decade or so ago, where you had to really address cybersecurity at your practice. And the reason it's become such an issue is because more information's online. We use data instead of documents these days, more and more. And as you gather more data and more of your communications are electronic, and you end up storing that data for clients on your systems at your law firms have become major targets for cyber criminals. This is an ABA technology survey from last year, where they talk about exactly what I mentioned. In 2018, 26% of respondents reported that their firms have experienced some sort of security breach. Now, security breach is like this, like we point out here, it could be anything from a lost laptop or stolen laptop, an inadvertent or mistake that causes some kind of breach, or somebody might have unauthorized access to information, or in what we all typically think of in terms of cybersecurity is that you've been hacked by a third party, some guy in a basement or some foreign entity that's infiltrated your computer systems. So the 26%, that's pretty high.
Yeah, and I would just mention, in preparing for this webinar, and took a look at some of the statistics that are available out in the public domain. During this period, since the COVID pandemic, cybercrime is up 600%, which is astronomical. So everybody needs to pay particular attention now. But you look at some of these other stats, 230,000 new malware samples are created every day. Total infections have been on the rise for the past 10 years. In 2009, 12.4 million infections. 2018, 812 million infections. So, again, the Mueller quote, it will happen, and the idea is to be prepared. So, on to the next.
So, we put this slide up here, and this is data from NIST, and they have this graphic, which I think encapsulate these concepts here. Because even in my experience talking with clients, people have this kind of conflate privacy with cybersecurity, that they're synonymous, and they're really two totally different things. And they have an overlap, and you see in the middle of this Venn diagram. Privacy, really, you're dealing with regulations about how you deal and control data and privacy or personal information that you're authorized to have, and how you process that information. Do you share it with third parties? Do you provide notifications, required notifications under different regulations to your data subjects about what you're doing with that data? Now, that's all controlled by different privacy regulations. On the cybersecurity side, it's really about controlling and what systems or controls that you have to restrict from unauthorized access to information. Now, that information may not necessarily always involve personally identified information. It's typically called PII, but you could see in different statutes and regulations, it could be different abbreviations for the concept and how they define it. But cybersecurity also covers different types of data. We as lawyers have client data that's not always PII. It's trade secrets, confidential information, and for business owners, it could be confidential information about your businesses and your proprietary information. And it's this intersection in the middle where you have cybersecurity over PII, where you're protecting PII, the unauthorized access to PII, is where you have most of the issues that you would deal with when it comes to incident response, and definitely where most state reporting requirements and different statutory reporting requirements come into effect, is when you have unauthorized, or you detect unauthorized access to PII. And so some practices, so some lawyers would think, well, I don't deal with personal information of clients. I do patent stuff, and yeah, sure, okay, I get the concept here that I should be protecting that client's information. But if you're running a business, you always have access to some personal information of your own employees. You might have medical information about your employees for their health plans. You might have financial information about your employees because you're doing payroll, or you're doing 401k or whatever. So you have to think about controls over that stuff no matter what. And although it might be limited, you do have access to PII typically in any business.
Just really briefly, and further to your point about the distinction between cybersecurity risks and privacy risks, just a little to highlight and emphasize the unauthorized system behavior. As attorneys, as business owners, our systems, whether or not we are storing private data on the systems are vulnerable to attack. Trackers can be placed on web browsers that don't necessarily harvest private information, but may slow your system activity, may provide a route for bad actors to access your systems. So when we talk about cybersecurity, it's the whole universe of when you're interacting electronically or over the internet, or you're storing or communicating, the different considerations to keep in mind, which is a good segue into the next topic what kinds of threats are out there. You have to bear with me because I am new to the Zoom sharing. There we go. All right.
There we go.
So what kind of threats are out there?
And I would say that these are the top issues. You'll see these in the news all the time. People have varying understanding of the different subjects here, but we'll get into some of the details. Malware and ransomware. We've heard about ransomware, but malware is a type. Ransomware is a type of malware where it infects your system, and the intruder or the program takes control over your system. And in a ransomware situation, it locks up data until you then are asked by the perpetrator to provide cash or Bitcoin most of the time in order to get a code to unlock your data. Now, ransomware might not involve an intrusion to the data, as there's no be it may not lead to an instance where data has left your system, but somebody else definitely has control over it now, and it's locked up. And that's your basic ransomware attack. You have how does get malware and ransomware get on your systems? Well, there's a lot of fake websites out there, thousands of fake websites that when you are get an email from someone you don't know, or even maybe someone you think you know, or it looks like you know, and they direct you to link on something, to link out to a website. That website now installs something through your system, and now you're subject to a malware attack. Or it asks you to visit a website, and the fake website just as you pass through the website, unbeknownst to you, you're downloading this ransomware onto your systems. And everybody has the concept that we've all seen in the movies of these hackers that, they work hours and hours, and they're all eggheads, and they develop these software to attack your systems. But these days, as you know, a lot of software is very user-friendly. And on the dark web, you can get software packages that are already existing that will serve as a base for you to recode and use yourself for ransomware. So there doesn't take a lot of knowledge or expertise to develop a ransomware attack if you know where to look. This phishing and spear phishing is a way where you're contacted by someone you think you know, or that they, in order to elicit personal information from you, or business information from you. Most of you have probably experienced a phishing attack at some point, where what's pretty common is you'll get an email from somebody, it looks like who you think it is, like your boss. And your boss is demanding, send me that file, or, hey, I need this information. You know what? I gotta deal with something. Send me 1,000 gift cards from CVS. And surprisingly, you could send out these phishing scams in mass with millions of emails to go out. It's cheap, and you only need a couple people to get caught on the hook, so to speak. That's what they call it, phishing. Spear phishing is a more directed situation, like I mentioned, it's your boss. It appears that your boss is sending you an email. How do they get that information? How do they know you're going to respond to that? Is through either social engineering, we have it down here, where they gain access or for public information to create a very bespoke approach to you in order for you specifically to elicit very specific information. So the more specific it gets, the more it leans towards the spear phishing type of attack.
Yeah, I mean, and emails could be as simple as, congratulations, click here to claim your prize. It's really the concept of phishing is to, like Dave says, put a million emails out there get somebody to bite, get somebody to click. And then that gives the bad actor the ability to infiltrate the system.
The next one I wanted to mention was the business email compromise. And this one it takes very minimal technical expertise for the perpetrator to do this. And it's something that a lot of businesses deal with and a lot of law firms deal with, where it's basically your counterparty and on an email exchange, their system has been compromised. Their email system has been compromised. The perpetrator gains access to their email system, creates an account on their platform. So it will appear that they have an email address coming from your counterparty. And they monitor the email traffic going between you and your counterparty. Maybe a trusted friend, maybe somebody that you've done business with for a very long time. And they'll wait for the right opportunity to suddenly they'll cut off the counterparty and then take over as the counterparty. And then they'll start communicating with you as if they were an imposter. You'll never know, because the email address will be coming from your trusted friend. Maybe they change it, just a letter, and you don't really notice. And suddenly you're in the midst of a deal where, hey, I know for the last 10 years, we always send a check for this deal, but you know what? This time, why don't you send the money by wire? And here's some wire instruction. Yeah, I know it's an outside bank in Florida, and we're in Indiana. And yeah, but don't worry about it. And most of the time, people don't stop and ask, well, wait, what happened? Why is my friend or my business partner that I've been doing business with for years all of a sudden asked me to wire cash to him? And then the wire occurs, no one knows what happens, and guess what? The money, by the time you figure it out, is long gone, and it goes overseas. There's no way to get it. But this is a constant thing. It's an old time kind of intrusion that's very hard to detect, and the only way you really can figure it out is if you trust but verify. At those points, you want to have people that think about, take a step back, pick up the phone and call that person. Hey, why are we changing what we did for the last 10 years? I never sent you that email. Boom, you've discovered the fraud.
Yeah.
I also included on here, internal threats. And this is something also, people think about cybersecurity as, hey, an external intrusion. Employees steal data. People that you've trusted in your own organizations can be threats. So that's something always to consider and monitor activity of your own employees when it comes to what data they have access to, what data that they're taking or restricting access and ability to take. And it all comes down to law firm as a target. And I think Brian can talk a little bit about that.
Yeah, certainly. Law firms are almost repositories of the treasure troves of information that, really the targets of these scams. And we tend to receive proprietary information, financial information, medical records, documents that could be used to elicit money, to make people look bad. Law firms need to be on the lookout for this. And when we say law firms, I think we mean attorneys, we mean solo practitioners, we mean legal departments, in-house legal departments, anybody engaged in the practice of law. And it really is incumbent upon everyone. Really, the very first thing to do is just slow down and think about how you practice, how you come into contact with how you use email, the people that you correspond with electronically, what kind of data you're receiving from your clients, and especially for law firms, what procedures and policies do your clients require of you with respect to their representation, with respect to their data, with respect to communications? It's very important to be on top of this because, you know, really law firms are coming into focus as a prime target, and it needs, again, 600% increase in cybercrime since March. So there are ways that the first way to respond is to prepare. And, you know, I think by sort of thinking these things through, considering how you may be vulnerable is of utmost importance.
Yeah, the only thing I'd add to why law firms are targets is cyber criminals aren't, you know, they're not stupid. You know, they know where the data is. A lot of law firms advertise, you know, it's a business. You advertise the kind of clients you have, the kind of business you do. That's all public. That's very easy for somebody to figure out where the stuff is.
Yeah, and public dockets, when you're filing information and it's publicly available, it's very easy for someone to access a court's website, find out who the attorneys are on a matter. You know, maybe it's a significant amount of money involved, and they're really able to again, the social engineering piece, the spear phishing piece, really able to sort of zero in on how to best get this information out of your hands.
Well, I think as well for law firms is, so if you're working for major financial institutions, insurance companies, etc., I think cyber criminals are pretty savvy. They know that those big institutions spend a lot of money on cybersecurity. So why would I go attack their systems when I can attack a law firm or any third-party service provider? Because that's all law firms are when it comes to data. You're just another vendor, basically, where you've been entrusted with data from your client. And so they look for these weak links. And historically, that the weak links in chains for data protection and cybersecurity have been third-party service providers. And law firms are no different when it comes to that. And I think that they've also picked up on the fact that, and we'll talk about it a little bit later, that law firms are some of the least sophisticated when it comes to cybersecurity. But that goes with you know, hey, listen, we don't go to law school because we're technological geniuses, right? But in any event, you know, we talk about the threats, and this is where it comes down to. When you talk about phishing attacks, and I think this is really important because I think this is where most of us are going to experience this in the practice of law, or even in businesses. You know, we deal with information exchange at light speed. You know, there was a time I remember we were talking to Brian about it the other day. Is like, remember when we used to send letters to people? Well, that was too slow. Now we send emails, and now that's too slow. And so we have instant messaging. There's that demand that you want to be responsive immediately to somebody's concern, a client's concern. You don't want to have them wait 5 minutes. If your boss communicates with you, you want to respond immediately with the answer. And that's what these cyber criminals prey on, is that they understand how this works. They're going to prey on that instinct that you have, and they'll send you emails. And this is the typical like byline or ray line of a phishing attack. Urgent, immediately need response, a forward that you don't expect. Please read immediately, follow up. Delivery services notices. You have an urgent package that's coming. Check out this receipt. Oh, wait. There you go. It's a ransomware attack. Important messages for you. And always, you know, this is, for some reason, they never figured out how to spell check. And this is, you know, it's that the tone changes. If you're in a business email compromise situation, you might see grammatical errors in the emails that you get, that you think you're coming from trusted sources, where you know these people wouldn't make those mistakes. These are little things you got to be on the lookout for, that you pick up. And we talked about is take the time, step back, just take the moment to think about, who is sending this to me? Do I recognize this person? Do I need to open this? Is this something I expected? unexpected emails from people you don't know that ask you to open things are suspect. However, I know we have a figure on how many people open these emails, and I think it's in the well, I don't have it in front of me, but
yeah. I think it was 66% from the last time we looked at that. So 2/3 of people are going to be
two-thirds
clicking
of your employees, 2/3 of your employees are going to click on an email when it has this type of urgent ray, and it's a phishing attack. And we'll get to why training is probably the most paramount thing to be concerned about. But that's a lot of clicks.
Yeah, and all you need is one click.
It emphasizes that there's always, the cybersecurity is great when you're talking about the technological controls and the systems, what we call like castle walls. You build up huge castle walls to protect your important things. But if you have one person in there that's not going to lock the door at night or leaves the window open, you have an entrance to that. And your cybersecurity controls are only as good as the people have access to the data that you're trying to protect.
Right. And, when it comes to law firms and lawyers, transition here, I mean, it really comes down to ethics, the rules of professional conduct, the scope of the representation of your client, the competency of the representation, and your diligence. So, lawyers have ethical obligations to provide competent representation. And what is competent includes having the skill, thoroughness, and preparation reasonably necessary for the representation. And the ABA has made clear that staying up to date with technology and the risks associated with relevant technology, which would include cybersecurity considerations, is required. So, again, I encourage everybody who's a practicing attorney to take a step back and just think about how you practice. Think about the risks that you encounter on a daily basis when you sit down in the morning, when you're communicating over email, when you're sending instant messages, when you're making phone calls. You need to be aware of the risks, and you need to have taken reasonable steps to minimize the risk of unauthorized access. So when we talk about client information, representation of clients, there's a duty of confidentiality. We must maintain and enforce the confidentiality of our clients' materials. Whether it's correspondence back and forth, whether it's their tax returns or medical records, there is it's imperative that the confidentiality be maintained. So in 1999, the ABA considered email to see whether or not that was an appropriate means to communicate with a client or about the client's representation. And the ABA said, yeah, there's a reasonable expectation of privacy in email. That was in 1999. So in 2017, they gave it another, they sort of thought through the changes since 1999 and issued new guidance in ABA Formal Opinion 477, which, there may not be a reasonable expectation of privacy in email. It breaks down into whether it's your email, your personal email, your personal equipment, whether it's an email system that's provided by your employer, where perhaps the IT folks have the ability to access, may break privilege. I mean, you need to think through how you're communicating with clients, what email address you're using. If I send what I believe or what my client might believe to be a privileged email to a client's business email, where anybody in that organization or others in that organization may be able to access that correspondence, that breaches a privilege. And that may open up discipline based on ethics violations. So really what Opinion 477 lays out is 7 considerations that you kind of, again, you take a step back, you think about your practice. And the first is to understand the nature of the threat, understand the information. Really it breaks down into just understanding the nature of the threat, being prepared, understanding the information that you are transmitting and that you're storing, understanding how to secure that information, what options are out there, and making sure that, like David mentioned earlier, that there's training, that there's policies, that there are procedures, that you've memorialized this training, and that you have means to respond if and when necessary. And that, again, after opinion 477 back in 2018, opinion 483 made this a point. You need to have an incident response plan, specific plans and procedures for responding to a data breach. It's not an ethical violation to have been hacked. You don't need to be impenetrable. You don't need to be like, a castle on, what you need to do is use reasonable effort. And what is reasonable is going to depend. It's going to vary based on the facts of the specific representation, the facts of the specific breach. But certainly having a plan, having trained your team on the plan is really the first step. I'm with respect to breaches, you're a law firm. David, you want to jump in?
Oh no, we'll come back to this when we go to the
response. Okay, good idea. Let me mention right now, it's 103. Let me give the first CLE code, and I'm going to type it in the chat. The first CLE code is privacy. And let me just find the chat.
So, we talked a little about, well, here's the next step. What do? You have these obligations. And a little bit more about the obligations. You have ethical obligations. You have regulatory obligations. You might also, and if you do any work for institutions, you have contractual obligations to protect your client's data. Those all have to be considered when you create your, when you build your infrastructure for dealing with cybersecurity. The first thing we have up here is training. And the reason for that is it's the key. If you can have the best policies and procedures, you can have all the best bells and whistles of your technological controls, but if you haven't trained your personnel on on threat identification, the incident response practice procedures, or just you're not informing your staff as lawyers, where you have obligation and you have to tell your staff the types of data that they deal with could be subject to different controls. If you deal with medical information, for instance, you might be covered by HIPAA as a business associate. But it's incumbent on the lawyer then, or the law firm, to make sure that everybody that has access to the data understands what it is, understands the importance of protecting it, and how to protect it. And so we talk about, things about how to reduce your exposure. The big thing for me is one of the things that you have to have as any part of cybersecurity program is the data management practices. Well, you want to reduce your exposure to make sure you are retaining only what you need. Retaining only what you need consistent with your client's requirements. If you're dealing with institutional clients, they're going to have their own independent document retention practices and procedures for their different outside counsel. And you'll have to know that and train your people on what they are. And then have a practice of ensuring compliance. Using strong security measures. This is it seems like a no-brainer, but we laugh when we talk about this. Where hey, we could probably guess most of you people's passwords. People still use the top 200 list of worst passwords. You can look it up online, and if any of your passwords that you use in your personal life and definitely in your business are on that list, immediately change them. This is softballs that you're giving people. And this message has gone out for a long time. Have very sophisticated password controls. Or if people aren't going to do that themselves, implement policies and controls that require very strong password controls, and use multi-factor authentication. You should be doing this in your own personal life to protect your own personal data. There's no reason not to do it when you're protecting the data that you've been entrusted to by your clients.
And just real quick, just for what is the multi-factor authentication, what that means is just simply, if you're entering a password, in order to access, you also need to have, responded on your phone. You maybe get a text message with a code, or you have another email where you're just like making a second sort of proof that you are who you are.
And these things are readily available with off-the-shelf systems and programs. You can get it even, multi-factor for Gmail, etc. Encryption's a big deal. If you're dealing with institutional clients, they might require that you have encryption on your communications and then their data when it's at rest in your systems. Always an important thing, because if, for instance, somebody does get access, can they use it? Can they do anything with it?
And it can be an ethical violation not to encrypt. It's really the essence of that opinion 477. I mean, if you're transmitting via email and it's sensitive information, you have a duty to encrypt. You have a duty to take reasonable steps to prevent unauthorized access.
So this last one is, verification. Trust but verify kind of thing, where, hey, yeah, the joke is, hey, the prince from Africa wants you to send them $100,000. Well, the same thing happens with lawyers. It's just a different scam. Hey, I need your trusted representation on an issue. I need it right away. Can I send you some money and then you can have it in your account for me, and then send me a check, and for all after that's all said and done, check doesn't clear, you've sent out money. But it's kind of like these people are pretty smart. It's the old school grift that you're dealing with. They're going to prey on that. Oh, I need the business. I want to land the deal. I want to get that new client in. And they'll prey on that to try to get you to trust them to do things for them. And this is never going to go away. This has been around for forever. And it's just a new way where they do it through email or different communications. And it's, again, if you're dealing with clients through emails, and this is that man in the middle, or that email interception, check your information, check the grammar and tone of the communications we mentioned. Always pick up the phone when you can. Can't hurt. Can you verify that number for me? If something seems out of the ordinary, pick up the phone. And this goes with people too internally. There have been cases where CEOs send a CFO an email in the middle of the night over a holiday. And they always do it around the holiday because they know people don't want to spend time on stuff. Hey, I need you to wire this stuff out immediately. Well, CFO's on vacation, doesn't want to deal with it, gives it to somebody else. Turns out that email never came from the CEO, and you've wired information and money out based on an instruction from a criminal third party. It's that verification. Why am I getting this? And it's, again, we go back to those ray lines: immediate, urgent. They're going to prey on that instinct to respond immediately to resolve an issue. So just be on the lookout. Security
is going to add a level of, it's going to add delay. It's going to add a level of inconvenience. You know, nobody wants to type in a 16-character password with a bunch of different symbols and underscores and numbers and letters, but taking an extra 10 seconds to type in a password versus the inconvenience of having the data taken or locked. And it's the same, pick up the phone. But once it's out the door, whether you're sending an email, sending a letter, wiring money, once it's out the door, it's too late. So it's better to verify.
I think, Brian, people like want to look at it, oh, this is very inconvenient to have to take these extra steps. And I think it's because, and I want to believe it's because they don't understand that this can happen to you. And it will happen to you. We gave you the stats. It's going to come around where it's not just you, right? It's your staff.
Yeah. And David, you know, on this verification piece and the inconvenience, you know, we were talking the other day about, you know, taking that extra moment when you're typing out an email to make sure that as you're typing out, you know, John Smith, that it's actually the John Smith that you're intending to send that document to, and not the, you know, the adversary with rabies that is just waiting for you to mess up, or the Wall Street Journal, or, you know, somebody else that is a contact that's in your calendar. You know, one of the things, turn off your autofill for your emails. You know, as you're typing out an email, the to and the CC should be the last fields that you fill out. Craft your email, attach the attachments, give it a read over, make sure it's okay to send, and then put in the to and the CC fields. It's so easy to send an email too soon. And all you need is this one, drop your guard for one time is all it takes. So in any event, verify, it's worth the time. What do we do when there is an incident?
Oh, yeah. Well, that's the thing. Like, so we just talked about the inevitability. It's this, what do you do? Well, first thing you do is don't panic, right? You shouldn't panic, but I'm getting ahead of myself because we have to talk about incident response. You have to have an incident response plan. This was pretty striking from the ABA survey we talked about earlier. Only 31% of firms reported having an incident response plan. And that's really low when you have 26% saying that they got hacked. It doesn't take much. Any business, any even small individual practice should have an incident response plan. And it's just an outline, a mapping out of what you're going to do if something happens. That's all encapsulated at your fingertips, available to you, so you can implement that plan immediately upon notice of something going wrong. And you know, what should it look like? It really depends. It depends on your practice. It depends on it depends on the types of clients you have. It depends on if you have cyber insurance policies. But it has to be something that's specific to your business. But these are the kind of things that definitely should be in there. The designation of individuals and the team that's responsible for the implementation of the plan. Now, how your plan or what kind of team or individuals you're going to have on this specific response to address a specific issue is going to be dictated by the issue. So, for instance, if you have a ransomware attack versus somebody forgot a laptop on the A train, that's going to be a different response strategy, and your team is going to be created in response to that issue. You might not need certain people, but you want to have your lineup ready. You want to have that deep bench. You might have to have or want to have outside counsel on retainer. You might want to have outside experts on retainer, an outside PR firm on retainer. If you have a cyber security policy, that might be also one of the first things that you got to consider implementing, and then contacting your carrier. And then they're going to assign a panel counsel and a panel outside expert to come in and do part of this job. But the idea is that you have something with all the resources in it. And if you have a cyber insurance policy, attach the policy to the plan. Have your lists of who all your key communications internally, externally are. Know all your clients, if you have institutional clients, and they have specific
It's possible David has frozen mid-sentence, but his point is a good one. Certain institutional clients are going to have policies and procedures that are part of the representation. It's going to be a requirement that you follow their policies with respect to these types of incident responses. Now, another thing to consider is, this is not something that, oh, it happens, I'll get to it. This is time of the essence stuff. I mean, this is the kind of, I jumped in right where I finished your sentence on.
I love it. I love it.
Yeah. And I was talking about time being of the essence. I'll let you, when we get to that.
Well, yeah, time is of the essence. So again, this is going to detail your process for investigating the issue, finding out what happened, documenting what happened, interviewing the people that you need to interview in the process. So you have a documented process, making sure maybe you have outside counsel involved to ensure that that's a privileged process. And then at the end, who you need to notify. It could be that you don't have to notify anybody, but probably going to have to notify some people. We'll get to the notification process.
Yeah. Okay. I'm clicking. There we go.
Okay.
So,
so this is just a general concept here that not every incident is a breach. So every security incident, every security breach is an incident. For instance, you have the laptop that's left on the train. That's an incident. No way that's definitely a security incident. Whether or not that leads to a breach, meaning that somebody had unauthorized access to data on it. Well, for instance, what if you find out, hey, the computer didn't have any information on it? Great. You still you had a security breach, but or a security incident, but didn't result in a breach that would require the implementation of the plan. So that's just a general concepts here. So when we talk about incidents, day to day, you can have many, many security incidents. It's when there's that breach, when somebody gains unauthorized access to information they're not supposed to have, that's when you have a breach.
Let me ask really quickly here on this point. And this may not be on subject, but an incident. Let's say you're authorized to have the data. Say you're a broker or a trader at one firm, and then you take this data with you to another firm. So you have the right to that. You have been entrusted that data. You're an authorized person to have access to that information. But let's say you're taking a client list with you to another firm. Is that necessarily a breach?
Well, it could be if you're a violation of policies at whatever institution you're working at. Well, I'll tell you this, it's definitely definitely a privacy issue because if you're taking client data, that client under your privacy notice and GLBA, you haven't notified them that you do that, you have a privacy issue. So you're running against a regulation, but you might also have a security incident, and it just depends on the circumstance.
Okay, yeah, I just wanted to mention that quickly.
Here you go. Don't panic. Because you shouldn't have to panic, because if you've done the homework, you'll be able to break the glass, pull out your plan, and start working on implementation and assembling your team, starting communicating with who you need to communicate out the gate. As we mentioned, it could be insurance, could be attorneys, could be outside experts or consultants. And then figuring out what happened, stopping the leaks, so to speak, getting a handle on what happened, keeping it from happening further, And then having your communication plan in place, where you definitely have the red phone access to everybody in the institution that you need to have access to at your fingertips or at your clients. So you can immediately start that process with notifying clients, because some clients and institutional clients, they might want to be notified whether or not the breach impacted their data. The very fact that you had a breach might trigger an obligation on you as a law firm or you as a third-party service provider to communicate that to your client, that you had some events or some breach, whether or not it impacted that particular client or not. But you have to know all those things and have that information available at your fingertips on who to notify and how to notify them. But when you go into notification, well, it's notification process. It just depends. It's going to depend on a lot of things. It's going to depend on the type of data. If, for instance, all the states and all the territories have data breach notification requirements and statutes. For the most part, those are only triggered when the data that has unauthorized access to is PII. We're not going to go through a state-by-state analysis of it, and this is where you scream out for the hope that there's going to be some kind of federal legislation overarching, because every state defines PII differently, defines what constitutes a breach differently, constitutes what has different requirements on the timing of notifications, who you need to notify. Are you going to notify clients, or are you notifying regulators, or both? So it all depends on the state. You also might have, depending on the type of data, if it's HIPAA covered, you're going to have to, deal with the particulars of the breach notification requirements under HIPAA. But so you might also have to notify, depending on the type of data, major credit card service providers to give them on notice, depending on the type of data. You might then have to make notifications to different credit agencies. But the key is, if you have insurance coverage, to think about whether or not you need to contact your carrier. But in addition, there's always this issue, well, do I need to contact law enforcement? And this is something that there's no one answer for that, because a lot of companies are reluctant to do that because they feel that it's a reputational issue if you get law enforcement involved. But it depends on what your goal is. If it's a client or if it's an employee stealing a laptop with data on it, that's a theft that law enforcement could add value to your investigation and catching the perpetrator and stopping the breach. But I think for the most part, people believe if they've been hacked, and it's a data intrusion that's been removed from your systems, that trying to get it back, and it's not worth the effort and slows your process down. But so that's all going to depend on the circumstance. Like most of these things are going to depend on the specific circumstances of the breach, the type of data that was impacted, and then what clients and types of clients were impacted.
Yeah, and speaking of clients, whether or not a specific client was a target of the breach or subject to the breach, there may very well be a duty to notify that client, whether there's a breach affecting another client of the firm, but you may have an ethical obligation to notify all clients that there was a data breach. And in at least in the state of Maine, that duty extends to former clients. So, under the ABA, they would encourage reaching out to former clients about data breaches to the extent notification is required. New Jersey doesn't speak to that. They say that, in fact, I have the rule here, it's beyond the scope of the rules, whether or not there's a notification requirement. And, but certainly in the state of Maine, attorneys are required to contact former clients and notify them about data breaches.
And so it just goes to show you that, you know, while you may have regulatory responsibilities for breach notification, you might have a state-by-state requirement to notify impacted clients. For lawyers, you have this additional requirement that may override all those other things. And your ethical obligations to contact clients in the case that they may or may not have been accessed their data.
Okay. So that wraps us up. I'll give the second CLE code. And again, I'm typing these into the chat. So the first code was privacy. CLE code 2 is security.
And you know, I would just want to state to everybody, you know, there's a lot to unpack here for an hour. You know, we can easily have spent several hours talking about any of these particular topics with you today. So I appreciate you hearing about this overview. And you know, I'm sure we've missed things, but or we didn't cover in depth as much as I would have hoped. It's just a matter of the time we have. But if there's questions, we have a few minutes to field some questions that came in. But always, you know, Brian and I are available to answer any questions you have offline.
Absolutely. So I just, you know, I want to thank everybody as well for taking the time. You know, certainly as David says, this is a broad area and there's a lot to think about. But I think the best way is as you're going through your day, you take a moment, you think about all of the instances where there's risk. When you're sending an email, when you're drafting an email, when you're opening a document, you know, if work from home, whether you've got client information, you know, this is not exactly cybersecurity, but if there's a window behind you and you've got important client information on your screen, you know, you may want to give that a thought about how your office is oriented. But there's certainly a lot of risk, and being prepared, being aware, being prepared are really the first two steps to having a response plan that will serve you well if and when you need it. So thank you, everyone.
All right, thank you, everybody.